The left, well, they're losing their collective minds today because Donald Trump's bond in that ridiculous case involving no victims whatsoever has been dropped today from $454 million to $175 million. Still a huge amount of money by any person's definition, but it is causing a lot of consternation on the left today. They're very upset that things are breaking Trump's way. For more on what's happening, I want to bring in Will Scharf now, a former federal prosecutor, an attorney for President Trump, and a candidate for attorney general in Missouri. Will, good to have you back with us, sir. Thank you.
Great to be with you. Thanks for having me on.
This seems like a pretty big decision, not least of all because it suggests that the court recognizes that the penalty imposed on Trump in the first place was totally over the top.
Yeah, I think that's exactly right. I think the court looked at our pleadings. They looked at our briefing. They understood that we have very, very serious grounds for appeal in this case. And they understood that the bond being required was just wildly disproportionate. The reason the left is melting down is they sort of had these pipe dreams of Tish James going around seizing buildings and airplanes and whatever else. And that's been thwarted once again just by a correct application of the law here.
Yes.
And it just goes to show how bankrupt this entire campaign of legal interference, of election interference being stage managed by the left against President Trump really is.
Is it true that that Donald Trump, as of the ruling, had about $500 million in cash on hand? I'm not sure if it seems to me that seems to be some of the press reporting on this. I'm not sure if that's a matter of public record. But if that is the case, it definitely looks like Arthur Engoron wasn't trying to impose a penalty so much as he was to explicitly impoverish the guy.
Yeah, look, as you said in your lead-in, I mean, this may be the first fraud case in American history, the first purported fraud case where there was no fraud, there were no victims. I mean, the banks all testified in our favor. The insurance companies testified in our favor. I mean, this is basically Arthur Engoron just pulling numbers out of thin air and trying to craft it as sort of a civil disgorgement remedy. I mean, the whole case is just totally lawless. We have endless grounds to appeal this thing, including the fact that the New York Appellate Division previously reversed him on a crucial statute of limitations issue. That was a ruling that he basically ignored in his final judgment here. So we're excited to get this case up on the merits.
Yes.
We're going full speed ahead here. And I think that original judgment, there's just no way it ends up standing.
The Washington Post today, in its coverage, quoted someone by the name of Adam Pollack, who is a former assistant attorney general in New York. And Pollack told the Post that he thinks that this is an extraordinary ruling today because he says the law is clear that you have to post a bond in the full amount. And it additionally suggests that there may be concern that the underlying judgment is itself excessive. So help me untangle this. Is it normal in any way for an appeals court to drop a bond amount, or is this pretty unusual?
So New York law is pretty clear that the courts have discretion in terms of imposing a bond or in terms of allowing appeal to go ahead without a bond at all. In this case, it's worth noting that part of the judgment, part of the underlying case involves a court-appointed monitor supervising the Trump organization. So there was no issue here of potentially disposing of assets or hiding assets or anything like that. We made the argument that in light of the frailty of the underlying judgment, in light of how excessive it was, that no bond should be required, or at the very least, the bond should be significantly reduced. And apparently the court found that persuasive.
Yeah.
In terms of this being unprecedented or strange, I mean, I'd say that the bond that Engoron ordered here was entirely unprecedented in New York history. There's never been a private party, other than maybe a big mega corporation that's ever been required by a trial court to post a $450, $500 million bond just to exercise their rights to appeal. So this whole case is just highly abnormal. And I think that's reflected in the way it's proceeded. And we're certainly hopeful that on appeal we get this whole thing knocked out.
Right. And the Associated Press, by the way, they dug in and they said the same thing. They have found no precedent at all. There is no other case that's ever looked like this in American history. That should tell you a lot.
Well, and we went to, surety companies, bonding companies in New York and said, hey, what would it look like for us to get a bond in this amount? And company after company just said, we can't issue bonds that high. I mean, it was a literal impossibility to post the bond that Engoron ordered here. And that really speaks to what we view as what was a key issue on the bond briefing, which is that President Trump has a right to challenge this case on appeal. I mean, he has rights afforded to him under New York law to proceed up through the appellate courts like any other defendant. And that was effectively being denied to him by this excessive bond. And we're happy that the New York Appellate Division saw things that way.
Yeah, the other piece that isn't getting much attention today, but I just wanted to highlight, that the appeals panel today also said that Trump is now entitled to once again start getting loans from New York financial institutions, that he's not subject to a 3-year ban on that, and that his sons, Donald Trump Jr. and Eric Trump, can indeed serve in a top position at a New York corporation, despite Judge Engoron's efforts to block that. Is that your understanding too?
That's correct. That's in the order this morning. Essentially, the appellate division stayed all the aspects of the underlying judgment that we would consider to be imposing potentially irreparable injuries on President Trump, his sons, and the Trump organization. So it was a wide-ranging stay. The judgment is not in effect. Tish James is not going to go around seizing buildings, and we're going to have the opportunity to appeal this case in its entirety, and that's the path forward now.
She was defiant today, though. She released a statement saying that Donald Trump is still facing accountability for his staggering fraud. And she went on and on. What do you think of her behavior here?
Well, look, Tish James ran for office on the platform of getting Trump. She's proceeded with this absurd case on an unprecedented, illegal legal theory that just doesn't make any sense
right.
when you cut it down to the bone. So I'm not surprised really by anything that she's said or done. But fortunately, we're in courts of law, and the law is ultimately going to end up being the decisive aspect here, not whatever statements Tish James comes out with. And I think she's just a little angry that she doesn't get to go around with her clown show attempting to attach assets and continuing to persecute President Trump and those close to him.
There is still a lot of pressure on Donald Trump, though. Over the next 10 days, he's got to come up with the $175 million. He sounded today a lot more optimistic about his ability to do that. Can you give us a sense, Will Scharf, of the logistics of that? How do you come up with money like that? Donald Trump did say he's got the cash to take care of it if he has to. What does that look like in the days ahead?
Yeah, he said that publicly, that the bond was going to be just taken out in cash, essentially. We'll figure that out. We have 10 days to work through that, and I don't want to get ahead of the team here. But we are going to be able to satisfy what the appellate division asked us to do, and our appellate rights are going to be preserved. But there are a bunch of other cases moving as well. I mean, we have a lot going on. We're apparently going to trial on the New York DA case. That's the criminal case brought by Soros-funded DA Alvin Bragg on April 15th. April 25th, we'll be in front of the U.S. Supreme Court on our presidential immunity appeal. So as always, we're keeping legal reporters busy here.
It's endless. Yeah, that was the other big news today, is that Alvin Bragg case will begin April 15th. That case, as I've been telling the audience, has been widely considered the single weakest case against Donald Trump, and the most ridiculous one, where Alvin Bragg is alleging some sort of electoral meddling by having a non-disclosure agreement with Stormy Daniels. Give us a preview of what to expect as that case begins.
So it's talked about as a hush money case, but it's really a pretty simple business records case. President Trump made payments to his lawyer, Michael Cohen, that he recorded as a legal retainer. And what Alvin Bragg is doing is he's saying, based on Michael Cohen's testimony, that in actuality, that money was being paid to Michael Cohen to reimburse him for payments that he made to Stormy Daniels, and that amounted to some sort of business records fraud. Now, Michael Cohen has been found by multiple courts at this point to be essentially a serial perjurer. The idea that you would base a criminal case on his testimony, just speaking as a former prosecutor, is insane to me. As you said, legal commentators have repeatedly deemed that case the weakest of all of the cases against Trump. And I think that's going to be borne out in the New York courtroom. The reason for the delay, because this case was actually supposed to already be on trial, is that Bragg's office had failed to turn over tens of thousands of pages of documents that our team was entitled to.
Yeah.
That's a situation that's been worked out over the last week or two, and it looks like we're going to go to trial on that. But again, to base a case on Michael Cohen's testimony It's just crazy to me.
It's crazy, and also just the idea that if Trump had a non-disclosure agreement with Stormy Daniels that involved money, how does that rise to the level of a federal election law violation? I mean, Michael Cohen didn't even go to a jury trial on that question; he just pled guilty to it. It's been preposterous from the very moment it was first alleged.
Well, and both the FEC and the Biden Department of Justice declined to take any action against President Trump on exactly this legal theory. So Bragg is really out on a limb here. I think that the indictment itself is legally defective in any number of ways. In addition to the serious factual issues they have trying to bring a case to trial based on Michael Cohen's testimony. But again, this isn't even really about payments made to Stormy Daniels. This is about the way that Donald Trump recorded payments to his own lawyer.
Right.
The idea that could amount to a felony charge under New York law. And frankly, it should be scary to every businessman in terms of the way that they go about recording their business expenses.
Is this the only trial that's going to take place before Election Day? What's the calendar look like in terms of the actual trials that the left is trying to force Trump into?
Yeah, I certainly hope so. The Florida documents case down there, that's an immensely complicated case with millions and millions of pages of discovery. I'd be surprised if that went to trial before the election. I'm hopeful that the Supreme Court does what we're asking them to do on presidential immunity.
Yes.
That would certainly push back any trial in the D.C. prosecution and probably the Georgia prosecution as well, long past Election Day. So in short, the situation we were looking at last summer where Trump was going to be forced to sit through trial after trial after trial at the height of election season, I think we've successfully thwarted that. I don't think that's going to be the dynamic, and I think he's going to have the ability to campaign vigorously to be our next president.
One other case I know that's before the Supreme Court that incidentally involves Trump, I think there's a number of charges that Jack Smith has been bringing about interfering in official proceedings. January 6 defendants are basically appealing this up to the Supreme Court, and the court's going to consider whether or not they were even properly charged in the first place. The crime that's supposedly involved here involves typically white-collar crime, the destruction of evidence that's supposed to go before Congress, not people being in the congressional building. And yet Trump is being hit with charges here, too. Are you hopeful that case will result in some of these charges against Donald Trump being dropped?
Yeah, so that's the Fisher case. It involves a statute called 1512C2, which, as you said, it was part of Sarbanes-Oxley. It was really about shredding documents in advance of a congressional investigation or a congressional hearing, that sort of thing. In the aftermath of January 6th, the Department of Justice has used that charge to essentially create felony cases out of misdemeanor cases with a lot of these January 6th protesters. Two of the four charges in the D.C. indictment against President Trump, one is a 1512C2 charge and the other is a conspiracy charge under the same statute. So certainly if the Supreme Court decides to strike down its use in those January 6 cases, that could easily result in two of the four charges against President Trump just disappearing. And that would affect the way that case could be brought. It would affect the sort of evidence that could come in on the remaining two charges. We're definitely watching that one very closely.
All right. And that would, of course, lead to more wailing and gnashing of teeth among the left, which we're getting a lot of. All right. Hey, Will Scharf, thank you very much, sir, and best of luck going forward in your race there in Missouri to become the next Attorney General. Thank you, sir.